Okay, today we are jumping into a topic that I know might sound a little dry. We're talking about how to change Canada's constitution. But stick with me here, because this is actually the secret key to understanding some of the most intense, high-stakes political dramas in the country's entire history. This is the ultimate rulebook for how the country itself works. So let's get into it. And really, there's no better way to get a handle on this rulebook than to tackle the single most explosive question it has ever had to face. Can a province, like Quebec, just decide one day, you know what, we're out? This was not some classroom debate. This was a real-world crisis that pushed Canada right to the very edge of breaking apart. So yeah, we're going to use the Quebec secession debate as our guide through all this. Think of it as the ultimate stress test for the Constitution. By figuring out how that whole drama was handled, we're going to see exactly what holds the entire country together. And look, this wasn't just some passing thought. The push for an independent Quebec was built on centuries of deep cultural and political differences. The whole thing got so intense that it eventually landed right in the lap of the Supreme Court of Canada. But to really get what they decided, we first have to take a quick step back in time. You see, here's the crazy part. For most of its history, Canada couldn't actually change its own constitution. I'm serious. So to understand the rules we have today, we have to see how Canada finally brought that power home. This timeline really tells the story. From when Canada was created back in 1867, all the way until 1982. That's 115 years. For that entire time, if Canada wanted to make a major change to its own foundational laws, it had to literally ask the Parliament in the United Kingdom to pass it for them. It was only in 1982 that the Constitution was finally repatriated, which is just a fancy word for bringing it home. That's when Canada finally got the full independent power to write its own story. So just to spell it out, before 1982, the process was basically asking for permission from another country. After 1982, the power came home, and Canada set up its own internal system with 5 very specific procedures, or formulas, to make changes. This was a huge deal for the country's sovereignty. The best way to think about these 5 formulas is like a constitutional toolbox. You've got different tools for different jobs, right? Some are for tiny little adjustments, and others are for massive fundamental overhauls. We're going to focus on the 2 biggest, most powerful tools in that box. First up is the workhorse of the toolbox. It's called the General Amending Procedure, and you'll find it in Section 38 of the Constitution. But pretty much everyone calls it by its nickname, the 750 Rule. And honestly, that name tells you everything you need to know about how it works. All right, so the 7 in 750, that part's pretty straightforward. To get an amendment passed using this formula, you need at least 7 of Canada's 10 provinces to give it the thumbs up in their legislatures. That's already a pretty high bar to clear, but it's only half the story. And here's the second part, the 50. It's not enough to just have 7 provinces agree. Those 7 provinces also have to represent at least 50% of Canada's total population. And as you can see right here, with Ontario and Quebec together making up well over 60% of the population, well, you pretty much have to get one of those 2 giants on your side to make the math work. Okay, now for the big one. If the 750 rule is the everyday hammer, this next one, the unanimity procedure, is the constitutional sledgehammer. It is saved for a very short, very specific list of things that are absolutely fundamental to the country. And when they say unanimity, they mean it. We're talking every single one of the 10 provincial legislatures, plus the federal parliament, have to say yes. There is no wiggle room. No province can just say, nah, we'll sit this one out. It is all or nothing. Okay, so let's just put these 2 side by side for a second. The general 750 rule is for big deals, like changing the Senate's powers. But that unanimity rule, that's for the absolute bedrock of the Canadian state. Things like the monarchy, the use of English and French as official languages, and get this, even changing the rules for amending the Constitution themselves. All right, we've got our toolbox. We know the rules. So let's get back to that massive question. How did the Supreme Court of Canada pick up this very toolbox to figure out if Quebec could just go its own way? The court's first decision was crystal clear. They ruled that no province could just unilaterally secede. You couldn't just, unsubscribe from being a part of Canada. Leaving would fundamentally change the entire country, and because of that, it would require a formal amendment to the Constitution. Which, of course, leads to the next big question, right? If you need a constitutional amendment, which tool do you have to use? Do you go for the flexible 750 rule, or do you have to use that incredibly difficult unanimity rule? So the court basically went down the checklist. They looked at that short list of topics that are protected by the unanimity rule, and they found that a province leaving would directly blow up at least 3 of them. It would totally change the role of the crown, it would affect the status of official languages for the whole country, and it would even mess with the makeup of the Supreme Court itself, since by law, the court has to have judges from Quebec. So the conclusion was, well, it was unavoidable. Because secession would shake these core pillars of the state, it triggers the toughest test in the toolbox. In order to leave Canada, a province would need to get a constitutional amendment passed with the unanimous approval of the federal parliament and all 10 provinces. So what does all this legal back and forth really tell us? What does having such an incredibly high bar for change say about the very nature of Canada as a country? Well, it speaks to the core idea of the Canadian partnership. You have to remember, Canada is a confederation at its heart. It wasn't one giant country that got broken up into provinces. It was the other way around. It was formed when a bunch of distinct, self-governing colonies agreed to team up. They didn't just melt into one big pot. They handed over some powers to a new federal government, but kept a ton of power and autonomy for themselves. And that is why these amending formulas are so critical. They're like a powerful shield designed specifically to protect that provincial power. They make sure that the fundamental deal of the country can't be changed on a whim or without a genuine coast-to-coast national agreement. Which leaves us with this huge, fascinating question that Canada is still wrestling with today. Is this incredibly difficult process a brilliant feature that protects a diverse and complicated country and keeps it stable? Or is it actually a bug, a system that's so rigid and so hard to change that it ends up preventing necessary progress? Well, the debate on that is far from over.